This is the journey to One Africa.
I want to speak about my advocates and how we're supposed to conduct the proceedings. So let us finish with the quorum, and then after that we address the court. I am done with the quorum prosecution. Honorable Magistrate, the accused is here, and now I think we are allowing for the mention. Now the accused, you're welcome. Thank you so much, Honorable Magistrate. Honorable Magistrate, as I have indicated, I would like to talk concerning my representation on these proceedings. And what I'm going to say, Honorable Magistrate, should be part of the records and should be recorded correctly. Honorable Magistrate, I have more than 30 advocates. And these advocates, I am the one that appointed them personally. They are my advocates. And I selected them because I have faith in their ability and competence to represent me in these proceedings. Most of them, I have worked with them. These are Elderly, Alute and Mpoki. These senior advocates have actually nurtured me professionally, but also for Alute, he has nurtured me literally. He took the position or role of my father, Dalisu. They are advocates that for many years that I've known them of impeccable integrity and competence. Now, Honorable Magistrate, today, where we are now, this is the 68th day since when I was arraigned before this Honorable Court and I read the charges on treason. 68 days. And from when the charges were read, Honorable Magistrate, you ordered that I should be taken to remand prison. And for 68 days, I have been in remand prison for 1 week in Keko prison, and since Friday, Ukonga prison. 68 days. In these 68 days, Honorable Magistrate, my advocates have come to visit me in prison in order to advise one another on how we can fight against these charges. They've never stopped coming or attending, or rather visiting me in prison. And all the time that they've been coming in these 68 days, they've never been permitted to see me and to communicate with me in confidence. They've never been permitted to meet me and talk to me in private. something what has happened if you go to Ukonga prison. Once you pass the reception, there is an empty room on the right side, and this small room is partitioned with a mirror wall, a glass wall. So when they come, they have to stand behind the glass on the reception, which is behind them, and then I stand on the other side of the glass wall. So we communicate by phone with advocates. We communicate by phone. There's no opportunity to exchange documents, and I have many documents with me. There's no opportunity to write anything because there's no table to sit and write. There's no chair. We have to talk everything through a phone line. Now, Honorable Magistrate, I have demanded over and over to the prison chief that I, as a prisoner that has a set of advocates, I have the right, a constitutional right, to see my advocates in confidence. It is my right. It is not the will of the jail. These are rights as I have them, and the jailers know this. In fact, Honorable Magistrate, there is one advocate who visited me, and I was telling the jailer, and they said, if phone communication is not possible, come to the reception. But at the reception you have prison officers on the second part of this door, and then I'm on the prison side of it, and all the prison officers are seeing me or listening to what I'm talking. Everyone is listening. Every prison officer is listening to what I'm talking. And even in phone communication, who is intercepting the communication? Who else is intercepting the communication? Who is eavesdropping? Who knows that there's another, who doesn't know, probably there's another person somewhere that is intercepting our communication. Who knows that? In the control room, there are no bugs that are intercepting sounds to capture the communication between I and my advocate. Now, Honorable Magistrate, let's go to laws. Because this is a court of law, so I would like to draw your attention to some legal provisions. I would like to read Regulation 13. Of prisons, prison management regulations of 1987. Prisons, in brackets, prison management, close brackets, regulations of 1987. Number 6 of 1987. GN number 630 of 1987, which reads as follows, and I'm going to read it in English and then interpret it so that everyone will be able to understand. So he's now reading in English, we can follow directly.
Of communication with his legal advisor, all such
Now this regulation that an advocate and an accused should not be eavesdropped when they communicate is part of the mother law, or is part of international instruments or conventions. And I would like to read the Board of Principles for the protection of all persons under any form of detention or imprisonment. These Board of Principles are known as the Mandela Principles. Mandela Principles. They were adopted by the United Nations General Assembly by resolution of the United Nations General Assembly, resolution number 43 stroke 173 of the 9th December 1988. Those principles on the protection of all persons under detention or are imprisoned. No. Patience a little bit as I'm searching for the relevant provision. Principle 18 of the Mandela Principles. 18, 1. He's reading in English, we can follow directly.
Shall be entitled to communicate and consult with his legal counsel. A detained or imprisoned person shall be allowed adequate time and the facility for consultations with his legal counsel. Three, the right of a detained or imprisoned person to be visited by and to consult and communicate without delay or censorship and in full confidentiality with his legal counsel may not be suspended or restricted save in exceptional circumstances to be specified by law. All lawful regulations, when it is considered indispensable by a judicial or other authority in order to maintain security and good order.
These principles, by the term other authorities, is also the court itself, and not a jailer or a prison officer that decides. It is the court of law that decides whether you should meet your advocate or not, or whether there should be restrictions. It is only the court that is vested with this authority, and I shall revert back to this position. Now, Honorable Magistrate, what we are talking about here, provision 4 on provision. Now, he's reading in English, we can follow directly.
And his legal counsel mentioned in this principle.
Start defending myself. I'm sorry for the interruption. There was a Parkat. I know that this case is a case on the charge of treason, and the punishment is death by hanging. I know that. I am aware. I also know that And if I go to the High Court, I know I'll be taken to the High Court. And during committee proceedings, where you won't be able to decide anything, Honorable Magistrate, I'll be able to defend myself.
I will defend myself.
I will have to defend myself. If there's someone worried that I won't be able, they should remember that I am also the judge. I'm also an advocate of the High Court and of the Magistrate Court for almost 22 years now. And in all these 22 years that I've served as an advocate, I have conducted cases in this courtroom, in the High Court, and in the Court of Appeal of Tanzania. Therefore, anyone worried that I want to get representation if I represent myself, they should not get worried.
I'm capable of defending myself.
I am capable of defending myself.
About me.
And this is about me.
It is about my life.
And my life.
Jesus carries.
He's not speaking in English.
Death by hand.
If there is anyone to be responsible, that person should be me, and not my advocate. Who have tried everything they can within their powers, but failed. Therefore, Honorable Magistrate, he's not speaking in English? No. That is number one, Honorable Magistrate. The second reason of this decision is that I have said, Honorable Magistrate, that we, as prisoners, even though I'm being called a prisoner according to these regulations, I have rights. Despite me being a detainee, I still have my rights. Honorable Magistrate, the first right that I have, according to these regulations and the prison management, is the right to worship God. Regulation 14 of these regulations, prison management regulations. But also, according to Mandela principles, I can bring it to your attention later. I have the right to worship every Sunday. Christians, I am also a Christian. Christians, the service is brought to them by the Ukonga Central Prison every Sunday. And in all Christian festivals or holidays, prisoners receive religious service or worship service. I was taken to Ukonga on Friday morning. And when I was received immediately, I asked the chief prison officer to go and worship during the on the Easter Sunday. I asked the chief prison officer that I would like to go and worship. He rejected my plea or my request. On the Easter Monday, I asked the jailer that I want to go and worship. He refused. And I have requested over and over, but they have refused all the Sundays, including yesterday. I was denied the right to go and worship. All other prisoners
wanakwenda
go to worship,
isipokuwa mimi
except I,
na wengine ambao hawakaja hapa,
and others that I'll mention them shortly.
isipokuwa mimi. Kanuni ya 14 inasema
Regulation 14 says,
the minister of religion, that is
who is reading in English, we can follow directly.
religion shall be admitted at proper and reasonable times to a prison to visit prisoners. Mtu kiongozi wa kiroho
A religious leader will be allowed to go to prison
unaofaa
for
kutembelea wafungwa,
appropriate time to visit prisoners,
kuwaambia habari gani.
not to inform them about anything.
Hakuna chai kuona,
There's no tea drinking.
kwenda
It's to conduct religious or spiritual service.
Waislamu every Friday,
For Muslims every Friday,
sisi wa Kristo
for Christians
every Sunday,
every Sunday,
every Christian holiday.
and every Christian holiday.
Wote wanakwenda
All go
isipokuwa
except
huyu mhaini
this treasonous man
ambaye hawezi hata kuomba Mungu.
who cannot even pray to God.
Hatakiwi, sio hawezi, hatakiwi.
He is prohibited even to pray to God.
14:3 inasema,
Regulation 14.3 says,
14:2,
14.2, and is reading in English,
Christians shall be permitted to hold religious services at such hours and in such places as the officer in charge may permit, and the officer in charge shall make such arrangements for the holding of religious services and for the religious instruction of prisoners, shall not in any way interfere with the routine and administration of the prison.
we, according to the law, we're supposed to be taught religion or religious instruction. In case you don't have a communion, these are things we're supposed to get taught in order to be baptized or participate in the Lord's Supper.
It is the law.
And 14.3 says, and is reading in English, we can follow directly.
And the religious instruction shall be voluntary. Sio lazima.
Attending religious service is not mandatory, it's voluntary.
Mimi nimekaa
I have decided to go, but I've been denied
siku 68.
for 68 days.
Kwa hiyo,
Therefore,
my right of worship
my right of worship
has been
is, arguing in English,
violated. Haki yangu ya kuabudu
my right to worship
imetupwa vibaya.
has been gravely violated, my legal right.
Na nimewaambia mawakili wangu,
And I've informed my advocates throughout.
wamenipambania sana.
They have fought for me so hard, but they have failed.
La tatu,
Number 3,
mimi ninakaa wapi gerezani?
where am I living in the prison?
Ninakaa wapi?
Where am I living exactly while in prison, Ukonga prison?
Mheshimiwa hakimu,
Honorable Magistrate,
Mheshimiwa, gereza la
Ukonga prison
lina sehemu kuu mbili.
has two main parts or sections.
Kuna sehemu ambayo wafungwa
There's the first place where all prisoners under prison life term, 30 years term,
kuhusu na hivi wanakaa
detainees stay.
wakiwa watatu.
They're grouped there together.
Alafu kuna
And
sehemu
then
moja
there is one place,
inaitwa special wing,
it's called a special wing,
eneo maalum ambalo
where
wanakaa wafungwa
stay where
waliohukumiwa adhabu ya kifo kwa kunyongwa.
prisoners under death sentence stay, those that have been convicted.
Mimi nakaa kwenye hiyo sehemu.
It's those where I am dwelling with those awaiting execution. So he's staying with the death row prisoners.
Sasa mheshimiwa,
Therefore, Honorable Magistrate,
kwa death row
if you're on the death row,
maana yake
what does that mean?
kusomea sheria.
Let me read the law for you.
Maana ya kuwa death row.
What does that imply?
Kanuni ya 33
That is Regulation 33.
inazungumzia wale walioko death row.
Talks about those on the death row.
Walioko death row. Inasema hivi,
This is what it reads, and it reads in English.
notwithstanding anything contained in these regulations, a prisoner under sentence of death shall A, be confined apart from other prisoners and shall be under the constant supervision of 2 prison officers by day and by night. Ukikaa death row
If you're on the death row,
kama navyokaa mimi
as I am,
wakati sijahukumiwa kifo, angalau
if I'm convicted of death, at least not yet, probably I will be.
sheria inasema
The law says
wanaokaa death row,
those on death row, those convicted and subjected to death penalty, are supposed to be separated from other prisoners,
wafungwa wengine wote.
all other prisoners.
Mimi nimekaa death row
I've been on the death row
tangu Ijumaa Kuu
from Sunday from Friday towards Easter up to this day as we speak
na
today.
nilitoka kwenda kuonana na mawakili wangu
And if I have to go and meet my advocates or my relatives,
na kuwakana na askari wawili muda wote.
there were 2 prison officers that go with me,
Kwa waliohukumiwa kifo.
as it is required for those under death row.
Kama walivyo ambao wako under constant surveillance.
I am under constant surveillance by day and night.
Mimi sio sijahukumiwa kifo,
I'm not convicted of death,
lakini nakaa death row
but I stay on the death row in under constant surveillance
by day
and by night.
ukiwa death row mheshimiwa.
If you're on the death row, as I have been,
Ukiwa death row, pamoja na kuwa death row, bado una haki.
you still have certain rights and entitlements.
Kwa mujibu wa sheria hii,
You have rights according to these regulations. For example,
kwa mfano, habari ya
I
haki ya
talked about the right to worship,
haki ya kuabudu.
the right to worship.
A prisoner under sentence of death
He's reading directly in English.
to receive visits by a minister of the religious denomination to which the prisoner belongs. For hata wageto wana haki ya kuabudu. Wote wanakataliwa.
All prisoners, even in death row, are supposed to worship, but they are denied this right, including I personally.
Ukiwa death
If you're on the death row,
pamoja na kuwa umehukumiwa kifo,
even when you are convicted of death,
a prisoner under the
a
sentence
prisoner under the sentence of death,
shall be allowed such amount of
he's reading in English,
as the commissioner may direct. Wanaruhusiwa kufanya mazoezi.
prisoners on the death row are allowed to exercise.
Kufanya mazoezi. Kwenye chumba changu napokaa mheshimiwa,
where I am living,
hapo death row. Death row imezungukiwa na
the death row is surrounded by a thick wall. Behind the prison cell where I am, there is a huge stadium, a football stadium, and all prisoners go there to play football and walk around. For those that are interested, for those that want to run, they do exercises as far as they want, except prisoners in the death row. These cannot go outside the death row walls. They don't have an opportunity to exercise, which the law has said they're permitted to exercise. No, I cannot play football because, as you see, the condition of my legs. But I can walk as a form of exercise. And since I've been on the death row, every day, from Monday to Friday, I just rest on Saturday and Sunday because God rested on the seventh day, so I rest.
From Monday to Friday.
But from Monday to Friday, I walk around the 4 blocks on the death row because there are 4 blocks. No. This area, there are streams of wastewater. The place that I walk around, and these are places where prisoners on death row go to wash their clothes. This is where they go in the morning to rest. For me, I am supposed to negotiate on these streams of wastewater, and one leg is not working properly thanks to unknown assailants that attacked me. I walk every day, and all days I have this fear that what happens if I trip and fall down, because these streams of dirty water or wastes are not for purposes of exercises. For exercises, there's a big playing ground behind these corridors of our death rows. But since Good Friday until this day today, 8th day today, I've never been permitted, or anyone else in the death row, to go and exercise, and the law says they are permitted to do that. Therefore, Honorable Magistrate, I have said
regulating the prisoners in the death row. What are the regulations of Prisons Act? Item 58. Look at the item 72, Honorable Magistrate. Section 72 of the Prisons Act.
A prisoner under the sentence of death shall be confined apart from other prisoners in a special cell or ward, and the treatment.
Okay, he's not speaking in English. You can proceed with him.
The treatment of the prisoner under sentence of death shall be as may be prescribed.
And the law, the prison services says, for us who are not in death row inmates, we are not supposed to be mixed with the death row prisoners. So it is now in the act. I have told my advocates for the 6 to 80 days that I've been in the prison, they have tried their best, but they didn't make it. They have failed. Now, Honorable Magistrate, my advocates have told me that I'm now coming to the court, Honorable Court, My advocates have told me that they have raised these issues before your honorable court. They have raised these issues on these violations of the rights of the prisoner or the detainees. They have drawn your attention on this unlawful treatment of the remand prisoners. And they have told me that the response that they got, that the court cannot interfere prison services regulations. Now, Honorable Magistrate, this stand, if it is true, if it's true that you have told them this stand violates the law principles of this country, you are completely out of step with the law of the country. Honorable Magistrate, you are visiting justice here. You are one of the people who visit prisons. This law says that in Regulation 48, I'm looking for that section. Kindly be patient with me. But the input of the provision is that a magistrate is a visiting justice of all the prisons under his jurisdiction. You are a visiting justice of all prisons here in Dar es Salaam, including Ukonga Central Prison. Why do we say that you are visiting justice in that regard? Is it because you are an honorable magistrate? You are a judicial officer. You are a judicial officer. As a judicial officer, your duty does not end by the time you sentence a person. You have also to continue, even for those who have been condemned, to return to the prisons or to the remand prisons. You continue to supervise their treatment while they are in prison. Now let me take you to the regulations of Mandela Principles. Principle 4 of the Mandela Principles. It says any form of detention or imprisonment and all measures affecting the human rights of the person and any form of detention or the imprisonment shall be ordered by will be subjected to effective control of a judicial other authorities. Any form, yes, Principle 4 of the Mandela Principles. And when they have been called the principles, Mandela Principles, but they are named as the Board of Principles of the protection of all persons under any form of detention or imprisonment. Any form of detention or imprisonment and all measures affecting the human rights of the person under any form of detention or imprisonment shall be ordered by. Can't really follow him. Is he speaking in English? I've said, Honorable Magistrate, this word, other authority, is translated here, and I'm going to give you the proper provision that has translated that. But what is its impression here? It is the court, in my opinion. It refers to the court. It is the court that is supposed to have effective control over prisoners and detainees. So your duty does not end when you said take him or her to the prison. Your duty continues. That's why you visit prisons. And I've been told that recently I've been visiting prisoners as a justice. I've been told that about that, and I've been making follow-up on such issues. Now, Honorable Magistrate, the legal provision here is that it is this honorable court that is supposed to oversee, to control the implementation of the prisoners' rights when they are at Ukonga Central Prison or anywhere else. It is this honorable court, not the prison services officer. And I've told my advocates about this problem. They have tried their best. Valiantly, they faltered, but in vain. Now, Honorable Magistrate, there are so many things, but I'm going to summarize. Others, of course, we are going to, when we go to the High Court, we are going to raise them there. But for the things that I've raised here, before your Honorable Court, my advocates, I thank you so much for your hard work. You fought professionally, you did your duty, and you did it professionally. It is time to step aside. And let me do what I should do, I must do.
It is time to let me do.
Kindly follow him because he's speaking in English. Now, Honorable Magistrate, from now on, I'm going to represent myself against the public advocates. Thank you so much for your attention. Microphone, please. We are not getting the voice in the booth. Microphone, please. Therefore, from now on, the arguments are going to be responded to between the public prosecutors on the side of the part of the Republic and the defendant until he says otherwise. So now I request my advocates to come back, but now from now on, the defendant is going to represent himself as he has requested, and his request has been accepted, and the advocates have adhered to his request. Now from now on, it is between the public prosecutors and the defendant himself. Honorable Magistrate, I would like to request another thing, that is aside. May I please get a chair so that I can write, because this chair is too small, because I cannot, of course, sit comfortably here. Okay. The Republic, please, you have the floor. There are so many arguments that have been raised by the defendant, and I hope that you have recorded them accordingly. Honorable, do you see now the communication between my advocates? But please listen. I've already ruled out. I've already provided the. Now you are going to proceed on your own, please. What is the problem here? What is the problem, Honorable Mgwai? Mpoki, what are you saying? What is the problem here? So now, give instructions. When you are in the court, all security officers, when you are in the court, honorable court, as another, you want to give anything to the defendant, please proceed without any obstruction. If there is an argument, it should be addressed to me directly. But it is not bad to know before you share it so that there is no any misunderstanding. Noted, Honorable Magistrate.
Prosecution side. Honorable Magistrate, as we directed, his voice is really down. Our contention is, we have heard a lot that the accused has brought before your attention. If we understood him very well, they targeted to inform this court the reason why he does not want advocates to represent him. If we understood him very well, he was giving reasons why he thinks that he should defend himself. Another thing is one of the reasons why of informing your honorable court why he wants to defend himself, even though your honorable court has decided that they have discharged advocates, the defense advocates. We also think it's wise because 110, Section 110 of the Criminal Procedure Act allows the prisoner or the accused person to be represented, but anyone can deny their right to legal representation in lieu of representing themselves. So if the court has agreed that if the accused has denied his right to legal representation, then he has the right, and the court has ruled out that. But if you come to the fundamental issues that he has raised, these are issues that go directly on the prison's services as and how he has been treated. And there was no any other issue that here we are supposed to answer or respond to. The issue has been brought on his side, which means the prison's services haven't been heard on the issue. But if I understood him, Honorable Magistrate, I don't think this issue or the issues he raised on how he is being treated in prison, I don't think they came here for your Honorable Court to give a decision or rule on them. If we understood him, but he was giving reasons why he thinks he doesn't want to be represented by his advocates in favor of defending himself. But if there is any other issue where he believes prison services or any officer in the prison services hasn't done what the law says they should do, we say still he has a legal right to pray for prerogative orders, and specifically mandamus. And he says, and he is really a senior advocate, well experienced. He understands what is supposed to be done. in order to pray for the reliefs that is requested to a competent court. And these are asked or prayed for. This is regulation 4. Regulation 4 of Law Reform, Fatal Accidents and Miscellaneous Provisions Act. Regulations, rules. Law Reform, Fatal Accidents in brackets, Miscellaneous Provisions, Judicial Review, Procedure and Fees, 2014. Rule 4 allows or speaks about procedures for judicial review, and also it gives reliefs directly. And if you use this application, that's when now will be given the opportunity for both sides to be heard, and not in the same way or not in the manner in which your court received information which is one-sided. If laws are present and they've been cited and the prison services haven't orders that are inappropriate, prerogative orders are given by special application, as I've informed this honorable court, and there's a special procedure to follow. Where both sides will be given an opportunity to be heard, whether to establish whether what he says is true or not, because he has spoken just orally and we have no idea what is the position of the other side. So I think he should use these specific rules that I've cited so that your court will be moved to give specific orders where it is established that there is a certain authority that hasn't implemented its legal obligation, so that they're compelled to implement them. But everything is written in the law. Otherwise, after these words, I think we can now move from this and come to the requests of the prosecution. We came here for a mention, as we said. Honorable Magistrate, I think I would like to respond. Are you done? We are going to listen to your prayers later. Honorable, are you done? I am done. On which issue? On the requests from the prisoner, from the accused, about his submission on the treatment he is receiving in prison. Honorable Magistrate, on the allegations that the accused has brought against prison services, I think we should follow the procedure so that the prison services is also given an opportunity to be heard, rather than for this court to just decide on its own without following the legal procedure. I think we are done on our part as state attorneys. Honorable Magistrate, I have heard from the Principal State Attorney. Let me say briefly, Honorable Magistrate, I know the procedure for asking for prerogative order of mandamus. Not that I've forgotten about it or that I don't know it. I haven't applied for the order of mandamus not because I don't know it. Honorable Magistrate, I said while I was talking that legally this court retains control, effective control over the detainees or prisoners. I said, Honorable Magistrate, you are a visiting justice, and I said I'm going to tell you the legal provision, and this is 101, Section 101 of the Prison Services Act, subsection 5. He is reading in English, we can follow.
And justices of the peace shall be an ex officio visiting justices of all prisons within their respective areas of jurisdiction.
What I want, I've just informed the visiting justice to do your duty. So you're giving me information, so, and this is not a request. State Attorney, have you understood this is a report? If this was a request, I would have brought it. But this I've just informed the visiting justice. Therefore, State Attorney, have you understood now? That's what I understood him from the beginning. That he wanted to dispense his legal representation, but he spoke a lot of words. He was wordy. So I was saying, if there is what he was alleging, there was an opportunity, or there is an opportunity for him to make an application. But if it's just a report to the court that when they visit prisons, they'll be able to cross-check these allegations. If it is a report, I think even this court was not supposed to even ask us to respond to it, because it wasn't a prayer. If it's a report or information, we expect the court to say we have received it. Just those. me now say on your submissions, because it's information or report, I've taken them and I'm going to work on them administratively, not judicially. You're just right. This court has been doing inspection on all prisons in Tanzania and Dar es Salaam, and I, as in charge, I've been visiting prisons. Therefore, I'm going to work on it administratively. Yeah. Now let's go to your main request, Principal State Attorney. Honorable Magistrate in charge, as I said, we are bringing this case for a mention. According to 243 subsection 6 of the Criminal Procedure Act, this case is coming for a mention. With section 245 subsection 6 of the Criminal Procedure Act. After the investigation having directed the orders given under section 245 subsection 5. Therefore, for that reason, we are asking this court to postpone this case until another day or date that will be agreed to inform this court whether the case has been filed at the High Court or not. Are you done? Yes, Honorable Magistrate. Tundu Lissu. Honorable Magistrate, I am thankful for the opportunity again that this case should be dismissed as it is being prayed for. Honorable, if I understood the order of the court, the last order of the court of 2nd June was your Honorable Court will receive information on investigation and the stage at which the investigation is. We were informed on the 2nd of June that investigation is at the final stages of completion. And that they will be informed whether it's completed or not. Now, the Principal State Attorney is asking that we postpone again. The report or information is given is an oral informational report. Just words from the bar. That is not report or information which is envisaged in law. Honorable Magistrate, the Director of Public Prosecutions. First, let me start with how is the information or report supposed to be, and then I will come back to the provision he has cited, 245 subsection 5 of the Criminal Procedure Act.
wa mashtaka. Hiyo taarifa
The report
ambayo inazungumzwa
which is spoken of legally, which was supposed to be brought here,
ni taarifa ya upelelezi
is
ambayo
investigation report, which is under this provision.
iko kwenye kifungu cha 16
Section 16, Section 16, subsection 1 and subsection 2
ya sheria ya mamlaka ya uendeshaji wa mashtaka
of National Prosecution Services Act.
16
Section 16,
16 generally
but specifically 16.1 and 16.2.
mheshimiwa
Section 16.1
inampa
gives
mamlaka
authority
mkurugenzi wa
to the Director of
mashtaka ya
Public
jinai
Prosecutions
na mawakili wa serikali
and
na
state
wa-
attorneys
yake
in his office
mamlaka
authority
ya kusimamia upelelezi
to supervise investigation of criminal cases.
mheshimiwa sheria
Honorable
inasema
Magistrate, the law says
DPP shall be the head of operations.
He is citing in English.
Coordination of investigations, of criminal investigations. Head of operations. Ndio mkuu
he is the head
wa operesheni
of all the
kwenye
operations
masuala ya uendeshaji
on all issues touching on
wa upelelezi.
investigation of criminal cases.
Na mamlaka ya DPP
And the power of the
ni mamlaka
DPP
ya mawakili wake.
is the power of his state attorneys,
Kwa sababu sheria inasema
because the law says
kile ambacho DPP
everything that the Director of Public Prosecutions is supposed to do can be discharged by state attorneys under his office. And if they do or discharge those responsibilities, it will be counted that it's the Director of Public Prosecutions that has discharged a particular obligation. That is section 16, subsection 1 and 2. Now, Honorable Magistrate, subsection 2 says the Director of Public Prosecutions and by extension state attorneys have authority to order the investigations officer to direct them to give them report on the stage of investigation.
In exercise of powers,
He is citing it in
the
English.
director may require any authority mandated with investigative functions to investigate any criminal allegations that have come to the director's knowledge and furnish him with a report on the results of such investigations. And the director shall have power to order that investigation be conducted by an investigative organ prepared. And aweza hata kuamua
He can even order who should investigate a specific case,
ana mamlaka ya kuamua
but he has authority to order that an investigation report should be submitted to him. That investigation report is what we're expecting to receive here, not just mere and empty words from a principal state attorney.
maneno matupu
Mere words cannot break a bone. That's a Swahili saying. Now, Honorable Magistrate,
16.3.
Section 16, subsection 3 is what has given state attorneys power
The director may order that a state attorney coordinate an investigation of a crime, and every investigating officer shall comply with that order. Sasa mheshimiwa,
Therefore, Honorable Magistrate, between the Director of Public Prosecutions that we've never seen here in court and these state attorneys who are here every day when this case is brought, who was the authority of the investigation to order that investigation report should be brought and submitted?
it is my submission
It is my submission that it's state attorneys that have that obligation. The Director of Public Prosecutions have never been here. He doesn't have a case file. Those that have a case file, it's the state attorneys who understand what is happening are these state attorneys. They are supposed to give us a report that they received from investigators and bring it before your attention. Not mere words. Not mere words. If they say they don't have, the report, it is with the Director of Public Prosecutions. I am requesting your court to ask the Director of Public Prosecutions to come here and bring it so that they don't deceive the court. So that they don't say it is with the DPP. We want the DPP to come and bring it in person if they don't have it. I believe they have it. Because they're the ones that have the file, they're the ones that have the case all the days. This is the eighth day. If they don't have, then the DPP should come in person so that it brings a convincing report, not mere words. Honorable Magistrate, about Section 245, subsection 5.
The Director of Public
Then
Prosecution
he's reading it in English.
or that other public officer after studying
His voice is a little bit far, so I am unable to catch everything. Therefore, you must make reference to Section 245, subsection 6. Section 245, 6. This is what it reads, and he's reading in English.
Director of Public Prosecution or that other public officer after studying the police case file and the statements of the intended witnesses, besides that with evidence available or the case as such, warrants putting the suspect on trial, or he shall draw up or cause to be drawn up an information in accordance with the law, and when signed by him, witnesses sent to him under subsection 4, including any document containing the substance of the evidence of any witness who has not made a written statement.
This provision, Honorable Magistrate,
completely premature.
is mentioned here completely prematurely.
Completely premature.
The order of the court said they should bring formal report on the stage of investigation. That was the order of the court. This provision speaks about investigation that is completed and the files have been brought to the attention of the DPP, and he has read them and he has decided whether we go to court or not. Now wait a little bit. Katuga, can you respond to that point? before I allow him to finish. Is that what you meant on that provision? Honorable Magistrate, what I was saying, the case file has been brought to be read in compliance with section 245. So do you have the case file? That's what the provision means. That's what I was saying. So they have the case file. So what is the stage of the investigation? What did you mean? Honorable Magistrate, what I'm saying, the case, after we have complied with further investigation, that is section 245 subsection 5, it has been now brought to be read in preparation of taking the accused to the High Court. That's what this provision is supposed to say. Now, I don't understand where exactly am I not being understood. Tundu Lissu, have you understood? I have understood him. And that's why I've said he has brought a cart before the horse. He was supposed to understand, to comply with the order of the court. One, Honorable Magistrate, you gave an order that they should bring a report, that I've said, that they should bring a report. What is the stage of investigation? Honorable Magistrate, that we have completed investigation and this is the report. And then second, then he has to say, because investigation is completed, Honorable Magistrate, we have now taken the Director of Public Prosecutions has received witness statements and the case file, and now he is reading the case file to decide whether to prosecute or not to prosecute. Wait a little bit. Is it correct what the accused person is saying? About what? You've understood him. Fundamentally, you're speaking one language, but this is interpretation. The accused person that has elaborated to the court is a 22-year-old experienced advocate that has tried to say how is the submission supposed to be done smoothly in order to inform the court. How have you implemented its order? That's what he was saying. So I was expecting you to answer what he said. Is it right or improper for me to record? I think he's supposed to say and then we answer. It's okay. Now, Honorable Magistrate,
investigation is already completed, and the file is already there and he's going to read it. Katuga, do you find it correct or not? Honorable Magistrate, I don't know why we don't understand each other. I think the file was returned for further investigation. And the further investigation has been conducted, and then the file has been sent to the DPP so as to be decided whether it has to be sent to the High Court. So that is the status of the file up to this juncture. So it is correct. Until we file it to the High Court, and we're going to tell the court that the file is already complete and it is now in the hands of the High Court. So I'm saying according to the legal provisions that we have. But when we decide, then we are going to tell the High Court that the investigation is already complete, and we are going to tell the court and submit the case file. You know, you speak one language. Now I understand you. Let us leave it to the DPP Mwakitaru to read the file, case file, and then we are going to meet so that we can be told after having gone through it what will be his decision. And I hope it will be in that way, so we don't have to continue postponing the hearings. That's why I said that you are speaking one language. You are speaking one language. I understand you in that regard. If we are ready at that stage, then the file is already completed, it is going to be ready. We are going to meet again after 2 weeks here.